before the break, we were talking about ways that you can own assets, specifically stocks and bonds in a brokerage account if you're married. So you can own them jointly together. It depends on, whether you live in a community property state. If you live in a community property state, then both spouses are seen to own, have a joint interest in those assets. But there's different ways that you can title the account. So if you are joint, if you title your brokerage account joint owners with rights of survivorship, then that means that both people own an undivided interest in the whole account. So when one person dies, the other person's interest disappears, and 100% of the ownership, if it's two people, goes to the remaining person or spouse in this case. There is another way that you can title it. You can title it tenants in common. So this is a common ownership type for people who are not married to each other. Maybe your brother and sister, or some other kind of arrangement. Or even if you are married, you can title your account as tenants in common. In tenants in common, each owner has unique rights to the property depending on the type of ownership. In both of these types of accounts, the benefits are that they avoid probate. So if you own something jointly, it makes those assets passable outside the will, so they become non-probate assets. Now, you still need to have a will or some kind of estate plan, whether it's a trust or a will or a combination of the both. You need to have something in place because you really don't want your state dictating what happens with the assets that you've had while you're living when you go home, hopefully to be with the Lord. So, tenants in common can be a way to pass assets, especially if you have a blended family. Let's say that you don't have children together. You're married. Maybe you had children. Your spouse had children before you got married, and you want to you want to pass some things on to those children. You can address that with that kind of a designation. Now, the other thing that I would strongly suggest that you consider is putting a transfer on death designation on your brokerage account and your bank accounts as well. Sometimes they're called payable on death. So POD or TOD are features that you should certainly take advantage of if your financial institution offers that, because when you have those kinds of designations on your account, then they become very easy to pass. If an estate gets caught up in court as part of the probate process, this could stall things out or cause assets to go to people that you didn't intend for them to go to. So putting that transfer on death designation, what happens when person passes and they have that TOD designation, it works sort of like a beneficiary does on an IRA account. You just present the institution that holds the account with a death certificate, and then the money is split up according to how you have it designated on the account. Makes passage very simple, very straightforward, and very quick. If you do have a blended family, though, you should seek legal advice from an experienced estate attorney to make sure that what you want to happen will happen. But before you ever go there, you need to make sure that you know what you want to happen. Those conversations can be very difficult, especially if you are in a situation with a blended family. You may make some assumptions that things are going to go a certain way. Your spouse may have a totally different idea. So those discussions are not exactly fun to have, but they are necessary. Otherwise, the last standing or the last surviving spouse gets to make those decisions if you don't address that while you're still alive.